the today's topic is little bit very relevant, and let me tell you बहुत important topic है. Important in terms of legal perspective, and there is a reason why statutory versus contractual makes a very interesting topic. Now, before I start saying anything about arbitration, anything what is statutory or contractual, just 2 minutes to understand what exactly is arbitration. Arbitration actually में concept क्या है, ये हम सबको पता है. आई एम प्रीटी मच श्योर कि ये ज्यादातर जो आज सुन रहे हैं उन सबको पता है कि आर्बिट्रेशन होता क्या है. बट आई एम जस्ट गोइंग टू अ वेरी लिटिल बिट डाउन एंड ट्राइंग टू जस्ट स्पीक आउट व्हाट एग्जैक्टली द आर्बिट्रेशन इज ऑल अबाउट. सी व्हेनेवर वी स्पीक अबाउट आर्बिट्रेशन, हम इंग्लिश को ब्रेकअप करते ही रहते हैं. Arbitrate, I mean to say let's talk, let's have a talk. So the moment I am saying let's have a talk, इसका मतलब यही होता है कि क्यों ना हम कोई भी चीज को साथ में बैठकर सुलझाकर, आई मीन जैसे हम आपस में बात कर ट्राई तो कर सकते हैं खत्म करने का, राइट. इसको पॉपुलरली अगर आप देखोगे, पॉपुलरली आजकल अलग अलग नाम होता है, जैसे कि आर्बिट्रेशन, मीडिएशन, कंसिलिएशन. डेफिनेटली लॉ बन चुका है. देयर आर लॉज रिगार्डिंग आर्बिट्रेशन, मीडिएशन एंड कंसिलिएशन, बट लॉज is mediation has not become a law as such, but arbitration and conciliation is a law nowadays. क्या होता था बहुत साल, आज भी अगर आप कोई भी रूरल एरियाज में जाओगे या आप फैमिलीज में जाते हो, कोई भी डिस्प्यूट होता है, if there is anything disputed, the first thing what we do is let's discuss, let's talk. बातें करने से बहुत सारा प्रॉब्लम्स खत्म होता है. ना, there's a very famous proverb that 99% of the problem is only due to miscommunication. मिसकम्युनिकेशन का इंटरप्रिटेशन थोड़ा अलग होता है. सो आर्बिट्रेशन, नाउ हाउ आर्बिट्रेशन हैज कम, हाउ इट हैज इवॉल्व्ड इनटू अ कमर्शियल लिटिगेशंस, हाउ आर्बिट्रेशन हैज बिकम अ टॉपिक टू से दैट द फ्यूचर ऑफ द लिटिगेशन is heavily dependent on the arbitration, and why we as a lawyer, we as a law student should really think arbitration as a part of our own practicing area, and why and on what basis arbitration has become a relevant part for any business community to increase their business. From business perspective, before I start legal, from business perspective, nobody, not even a single company, let me tell you, not even a big MNC or a very small company or a very small dhaba is interested in going to courts, or let me say is interested in having a dispute and to fight out the matter. Right now, I am just talking about civil part, right? I am not taking criminal part because arbitration criminals को लागू ही नहीं होता है. So when I say criminals, I doesn't mean in person. What I mean is criminal law. Okay. So commercially business बढ़ रहा है, economy बढ़ रहा है, world एक हो चुका है. The world has, the global world what we used to understand has become now एक मुट्ठी हो गया है. You can directly use your internet and you are everywhere, anywhere, whatever you want to do, right? You just आप Amazon या Flipkart ओपन कर दो, आपको जो चाहिए वो जल्दी आ जाता है. कहाँ से आता है, कैसे आता है, that's it. I mean to say is not relevant, but मार्केट छोटा हो गया है, but उसी टाइम बिजनेस का स्कोप बढ़ गया है. तो जैसे जैसे ये स्कोप बढ़ता है वैसे वैसे आपका डिस्प्यूट आना ही है. डिस्प्यूट्स आता क्यों है, उसका वेरियस रीजन है. आई एम नॉट गेटिंग इनटू दैट पार्ट, बट डेफिनेटली अगर आपका कुछ क्राइटेरियाज लेड डाउन है बिजनेस में तो डिस्प्यूट्स आपका कम होता है. सो आई एम जस्ट टेकिंग अ सिनेरियो जहाँ पे डिस्प्यूट्स होता है. So nobody is interested in going to the courts. Nobody is interested in wasting their time to going to the courts. The moment I say wasting of time, I'm not trying to dilute that system कि आप time दे रहे हो तो time waste होता है. नहीं. See what I'm trying to say, अगर मैं एक sales marketing बंदा हूँ, right? मुझे मेरा समय मेरे specialization पे देना है, right? As a salesman, if I'm spending my 4 hours in 5 days of working में 3 दिन में कोर्स में जा रहा हूँ just to prove myself, I'm telling you कहीं ना तो कहीं he will get into that burden, यार मैं कर क्या रहा हूँ, because मेरा वो फील्ड है ही नहीं, right? So nobody is interested in doing that court system और court part जहाँ पे मैं जाऊँ. वो अलग बात है कि हमें वो सिस्टम को फॉलो करना ही पड़ता है because we have a brilliant legal system, brilliant court system. ठीक है, कुछ loopholes होने वाले हैं, that's not a big thing. So now coming to this arbitration part, आजकल commercials में क्या हो गया है, the basic important is agreements. I'm assuming, whatever I'm saying today, I'm just making an assumption that we as a lawyer, you as a businessman or a law student, if you are a businessman, you are giving an importance to executing the agreement, right? अगर I already covered a topic on the contracts कि हम किस तरीके से agreements को हमारे business का एक strategy बना सकते हैं. I'm just repeating that line. Okay, having a law in your department or in your scope of plan, it only increases your business. It will never come down. Never, never. So the moment I say law, I'm just sticking myself to contracts. So make assume kar, I'm just trying to make an assumption that you are running a business and whatever business you are doing, you are entering into a contract. So now the question comes कि जब आप contract करते हो तो उसका relevancy क्या होता है? What is the relevancy of having each and every clause? I am not getting into each and every clause. I am just making a 1 minute submission is that जब आप कोई भी agreement करते हो commercial, right now if I am talking about vendor agreement, then what we do, आपका preamble आता है, आपका whereas आता है recitals, your scope of agreement, your pricing, your order, your delivery, your indemnity, your force majeure. Now I'm right now where I am stopping myself is dispute resolution. Let me tell you, ज़्यादातर आज भी we have this unorganized market. See, the moment I say unorganized, I don't want to put myself to say that Kina they are not doing proper compliance. No, both are different. Proper compliance is a totally separate topic. Unorganized doesn't mean that you are bad in business. No. See, the moment I am saying unorganized, it means that we are not giving importance to agreements, to contracts. So now this takes us to a place where एक बिजनेसमैन है, वो धंधा करता है, वो दो ही काम करता है. वो आपको माल देता है, फोन पे ऑर्डर आता है, आप उसको माल देते हो और आप उसको इनवॉइस रेज करते हो जीएसटी के साथ. और इनवॉइस में स्टैंडर्ड टर्म्स आता है जो आपको प्रिंट वाला बता देता है. उसमें ये लिखा रहता है ऑल गुड्स सोल्ड विल नॉट बी रिटर्न बैक, यू हैव टू पे 20% फलाना फलाना. दैट्स इट. अब मान लीजिए आपको पैसा नहीं आ रहा है, आप करोगे क्या? व्हाट ऑप्शंस यू हैव? अर्लियर what you could have done, you could have gone to the court filing a recovery suit, जो popularly हम उसको money suit बोलते हैं. आप सीपीसी में फाइल कर लेते थे. सीपीसी मीन सिविल प्रोसीजर कोड. आप क्या कर देते? आप समरी सूट फाइल कर लेते. ऑर्डर 37 ऑफ सीपीसी which is a far more better fastest remedy than CPC ordinary suit. आज के तारीख में आप क्या कर सकते हो? I'm just talking about remedies. Then everyone has their own restrictions. समरी सूट के बाद you can go to you can say NCLT, Insolvency and Bankruptcy Code. Then there is 138 section 138 का Negotiable Instrument Act. Everything is good. Everything has its own restrictions and limitations. Let's talk about arbitration. So now I'm just coming to this topic, contractual arbitration. Now contractual arbitration and statutory arbitration. मैं assume कर रहा हूँ आप लोग सब यही सोच रहे हैं कि what is this new fund of statutory arbitration? Statutory arbitration और कुछ नहीं है. It is just an MSME, Micro Small Medium Enterprises Act. Okay, contractual arbitration which arises from the contract which is done between two or more parties. MSME, not mandatory that you enter into an agreement. It's just that you are the part of MSME. Now इन दोनों का bifurcation मैं आपको बताता हूँ. Let me start with this contractual arbitration first. Arbitration का अपना एक कानून है, Arbitration and Conciliation Act 1996 as amended because it has been just recently amended. Now arbitration जब हम कहते हैं how it occurs, ये आता कैसे है arbitration? So when two commercial parties they enter into an agreement, एक clause होता है. Okay, arbitrations के भी दो भाग होते हैं contractual arbitrations के. एक होता है ad hoc contractual arbitrations और एक होता है institutional arbitration. Just to brief, जब दो पार्टीज कॉन्ट्रैक्ट एंटर करता है, I specifically see to it that there is a clause. Clause क्या हो सकता है? When I say ad hoc arbitration, it means any dispute, or you can say any or all disputes, or claims, or breach, or interpretation, or whatever you feel so, arising out of this agreement and between the parties shall be referred to Arbitration and Conciliation Act 1996 as amended. Full stop. See, the moment I put here, now what I am doing, I am binding these two parties. Now, both the parties are now legally bound, mandatory legally bound to comply with this Arbitration Act. मान लीजिए आपने इसी arbitration को clause इधर ही खत्म कर दिया, that's it. बट हमें ऐसा नहीं करना चाहिए, हम एक स्टेप आगे बढ़ते हैं. यही क्लॉज है, मैं उसमें आगे एक स्टेटमेंट ऐड करता हूँ. Arbitration tribunal will consist of sole arbitrator to be appointed by mutual consent of the parties. Full stop. अभी I have prescribed my own rules. Now this is where arbitration, I say, is little bit above the court system. Court system तो definitely is a brilliant way of doing the work, no doubt. बट जब मुझे कंपेयर ही करना है कोर्ट सिस्टम के रिकवरी मैकेनिज्म को और आर्बिट्रेशन को, देन डेफिनेटली आई विल प्रेफर आर्बिट्रेशन. उसका रीजन ऐसा है, आर्बिट्रेशंस में होता क्या है, यू बोथ द पार्टीज, if the clauses are defined or drafted in a very beautiful manner and without any legal interpretation and debates, then both the parties can appoint an arbitrator. We say umpire, arbitrator, whether it is 1, 3, 5, 7, 9, 11, everything has to be in odd figures, right? So that there can be an umpire. I have a right to appoint an arbitrator, and the best benefit of is you don't have to go to, you don't have to waste your time going to the place where you stand by 10:30 and you still standing there for your matter till 4:30, right? You know कि मेरा 11 बजे आज मैटर है आर्बिट्रेशन में, because I have appointed, both the parties have agreed to some appointment of an arbitrator. We go there, we inform हमें क्या करना है, procedures are prescribed and dates are given. How arbitration works? Now let me tell you this. So the moment I say any dispute arising out of this agreement will be covered by Arbitration Act, arbitral tribunal shall be appointed, shall be consisting of sole arbiter appointed by mutual consent. See, the moment I say mutual consent, मतलब A will inform B कि मैं ये appoint कर रहा हूँ, आपका approval दे दो. B अगर नहीं मानता है, then law comes into picture. वो मान जाता है, fair enough. अगर वो अपना नाम देता है और अगर A मान जाता है, fair enough. अगर दोनों में dispute होता है, then definitely Arbitration Act is there. In Bombay, you have to approach High Court under Section 11 to appoint a neutral arbitrator. Definitely, आप courts में तब जाते हो because if either of the parties just wants to delay the appointment of arbitrator. But ये appointment तो हो जाएगा. Now this is what I say ad hoc arbitration. So the moment I say ad hoc arbitration, it means I have a right to appoint an arbitrator to parties. Now I'm just revising this clause, just here to it. Any dispute arising out of this agreement shall be referred to the rules of Bombay Chamber of Commerce of arbitration, full stop. That's it. This is what I am saying, institutional arbitration. Now, what do you mean by institutional? Like there is a Bombay Chamber of Commerce, then there is Nani Palki Wala, then there is an IIAM, then there is an FICCI. They have their own arbitration rules and mechanism. Legally, it is legally bound. If I am saying legally, it is legally bound, it means the rules which are being framed by them are legally valid. So the moment I say that these rules will prescribe my arbitration mechanism, then I don't have to appoint arbitrator. What I have to do, I just have to issue a notice under Section 21 of Arbitration Act to the opposite party saying that since there is a dispute and you are not making an effort to resolve the dispute, I am making this matter, referring this matter to Bombay Chamber of Commerce as per their own rules. So procedure क्या है? यहाँ पे we put our efforts to appoint an arbitration. Institutional arbitration में there is already an institution. उनका खुद का panel of arbitrators होता है. You don't have to do anything. You just have to issue a letter to them and they will appoint an arbitrator. I hope you understood. Ad hoc and institutional. Today, if you ask me, I will prefer institutional, right? But yes, let me tell you, most of the financial institutions, they only prefer ad hoc. There is a reason behind it. I don't want to say why and what. That's a little bit different topic. See, the moment there is an institutional arbitration, everything goes as per the rules and everything is, I can say it is little far more better than ad hoc arbitrations. Now, the moment I say ad hoc and institutional, I'm assuming that aap sab samajh gaye ho. Now, what is the procedure? I will just brief it. Arbitrations, kaise, how to invoke the arbitrations. Now, see, let me tell you, before you invoke the arbitration, again, I'm just repeating one point. Don't try to copy paste arbitration clause from the websites. There is a reason behind it, because see, you will find a general statement there. Okay, you will find a general statement. I'm not saying it is wrong, but what I'm trying to say, use your mind to understand the relevance of arbitration clause. If you have an arbitration clause drafted by you and the other party when you are in a good negotiation, or about to close the deal, understand what exactly you want, make that procedure in your arbitration so that it doesn't create a deadlock between both the parties. So when you copy paste it, you really don't know what is the intention of that clause in your agreement, right? I'm just stopping here, and I'm just telling you the latest, recently how one clause, you can say it changes the whole interpretation of the documentations or your case. Now, what has happened in one of the cases, that there was a settlement deed which was signed, and one of the party had a checks, and they deposited the checks, and definitely the check were bounced, and the aggrieved party, he filed an application, he filed a complaint under section 138 of Negotiable Instrument Act. Okay, now that settlement agreement has an arbitration clause, and it had one more clause, that that clause speaks like this: the parties who are signing this agreement, it is assumed that they are legally authorized by the board resolution. Full stop. Now you might be thinking कि इसमें relevancy क्या है? ये तो एक simple सा statement है. But let me tell you how it has become a more relevant statement. Now what has happened is that when the A filed section 138 proceedings, now as per the Supreme Court judgments and the various rulings, you cannot make accused to all the directors. No doubt it is one of the good judgment, because there's a tendency कि आप सब directors को बना दो. Fair enough. But then I understand the pain of the aggrieved party, because एक तो धंधा भी मुझे ही करना है, माल उनको मिल गया, वो admitted है, चेक भी वो दे देते हैं. So now the liability has come on me to find out कि sign किसका है. So little bit I feel it is unfair to aggrieved party. But I am just going because we are following a binding precedent, and I'm pretty much sure when the Supreme Court has passed an order, it must have given some sense of thought, because they have the brilliant mind to do that. But as an aggrieved party, now what has happened to me when the matter was filed, okay, the particular court directed that you have to satisfy me why I should issue the summons to other 4 directors other than the director who has signed. So now what has happened to me is that I have proved who has signed the check. It took me an effort, but I have proved it. But now what about that 4? And there is a Supreme Court judgment that you cannot make accused on all the directors. Now that para 13 helped me in a very big way. How? Because it was the argument. It was an argument, of the lawyer of that particular A part, that since the settlement has been signed by the person, he was authorized by the board resolution. It means that the board resolution took place. There was a board meeting, and in the board meeting, the minimum quorum is 2. So I am pretty much sure that when the board meeting was held, all the directors were present. And if they were present, they have gone through the settlement deed. And since any agreement which has an effect on the financial interest of the company, that all the directors who were the part of the meeting, they agreed and then they signed. So the moment this argument was done, summons were issued to them. Now I'm telling you, such clause today has helped in one of the matter. So when I say don't copy paste, I mean use your mind how, and every clause will only come into role when you feel we have stuck in particular matter. So today that particular case has definitely became a part of it, right? So now again for arbitration. So draft an arbitration clause in a manner that it helps you. So when I say arbitration clause आपने draft कर दिया, contractual arbitration बन गया. How to process the arbitration? Suppose arbitration clause में है कि आप sole arbitrator करो, mutual करो. First mandatory step is I will prefer issue legal notice. Second, if there is no payment or if there is any dispute which has not been resolved, issue the notice under section 21 of the Arbitration Act. And let me tell you, issue it because it is mandatory and it stops your limitation there. It's suppose आपका कोई matter है 3 साल होने वाला है, today is 26 March 2022. Suppose ये 3 साल पुराना matter है, right? And your last date is 28th March. Now you have hardly any option because आपको 3 साल के पहले ही जो करना है वो करना है. Else If you go to the court, suppose court में कुछ ऊपर नीचे हो गया, suppose if you are not able to draft, the moment 3 years is complete, you cannot file any money suit. What you will do? Arbitration में issue section 21 notice. आप जैसे उसको issue करते हो और उसको मिल जाता है, your limitation stops, and then you are free, and then you file your case. Section 21 notice is mandatory. आपने फाइल कर दिया, now go what you have prescribed in your clause. एक arbitrator है, go with it. 2 arbitrator है, go with it. If you have chosen ad hoc, go with it. If you have chosen institutional, go with it. And this is the process how you need to proceed further, right? And let me tell you, there was one case actually where you need to be very clear that arbitrator can only be appointed as per the section 21 notice. Number one, it can only be appointed as per what you have prescribed. So before you take any matter, or before you file your written statement, make it sure that the appointment is legal, valid, and as per section 21 notice, and as per the agreement on the basis of which section 21 notice has come. Now, when I say contractual arbitration, क्यों करना चाहिए? I'm telling you the first part. I don't want to say it will save you a lot of money. I'm not going to do that. Because the moment I say, I know there will be a question कि नहीं बहुत सारा पैसा चले जाता है arbitration में, arbitrator का fees चले जाता है. I am taking from that point of view. See, the moment you do arbitration, there is a limitation. You have to complete the arbitration within 12 months, which you will not get in another remedy. Number one, you have to, that's mandatory. If you don't do it, then parties ka consent say you can extend to 6 months, 18 months. After that, no, you have to take the approval from the Chief Justice of Bombay High Court. I am just talking right now of Bombay. So just imagine that you file an extension. Definitely the Chief Justice Honorable Court will ask you, कि boss आपका इतना late क्यों हुआ? You should have an answer. Now suppose if you are one of the party, the other party will make a claim that they never came to the court. So whatever will be the thing, so you have a definite period of 12 months. 6 months definitely consent के साथ है, but take 12 months. So 12 महीने में खत्म होना है. आपको पता है टाइम क्या होता है? The first meeting when the arbitration starts, every date is being recorded कि आप कौन से डेट पे क्या-क्या करने वाले हो. So you know your dates, which never happens in courts because court has to go by the procedure which is laid down under CPC and CRPC for 138. You know the dates. You file, you argue the matter. Arbitration में whenever is your matter. Suppose 28th को you have an arbitration. You fix the time along with an arbitrator. 11 बजे, 11 से लेके 4 बजे तक. You can extend that time unless and until काम नहीं हो रहा है. There is no hard and fast rule that you have to comply कि नहीं 4 ही घंटा करना है. Just imagine you decide the time, you decide the venue, you decide when to argue the matter. I mean to say date wise. You decide when we have to file. Everything has to be decided between two parties along with the arbitrator. How easy it is. And then money part. If you go to the court, you have to pay the court fees. If you come to arbitration, there is no court fees. पैसा तो हर जगह जाने वाला है. I don't want to make any example, but definitely arbitration prevails in my view. Right now, I'm just talking about contractual arbitrations. Now what? Statutory arbitration. Now, you might be thinking जब इतना अच्छा arbitration का system है, what was the necessity of bringing this statutory arbitration, and what exactly is this statutory arbitration? As I told you, most of the business which are I will say MSME and below that, let me say majority is micro and then there's a small. आप उनको कितना भी बोलो, they don't want to get into this legal hassles because I understand क्या होता था आज से you can say आज से 15-20 साल पहले और before that. See, businesses runs on trust. आज भी ट्रस्ट पे ही बिजनेस होता है, नहीं तो एक क्रेडिट पे अगर आप ट्रस्ट करोगे ही नहीं, देयर विल बी नो क्रेडिट पीरियड. और क्रेडिट पीरियड नहीं है, देन आई एम टेलिंग यू एज अ बिजनेसमैन, बिकॉज आई हैव माय ओन बिजनेस, आप धंधा कर ही नहीं सकते हो. इफ यू आर एक्सपेक्टिंग कि ये वी आर लॉयर्स, दैट्स व्हाई वी आर सेफ, बिकॉज हम सब एडवांस ले लेते हैं. बट राइट नाउ इफ आई एम टॉकिंग एज अ बिजनेसमैन, मुझे कोई पैसा नहीं देता एडवांस में. वो 20-30% दे देगा, बाकी का बोलेगा रुक जाओ, क्रेडिट साइकिल है मार्केट में 60 डेज का, 45 डेज का, राइट. सो वी आर टेकिंग अ रिस्क नाउ. सो ट्रस्ट पे बिजनेस होता था, I understand, but laws have changed, situation have changed, सबका mindset change हो गया है. Now everybody have become more smarter than they were earlier. If I am saying smarter in terms of knowing how to avoid making the payment, बराबर है ना. पेमेंट अवॉइड के तरीके 50 है. क्या होता है कि आज भी लोग सिर्फ इनवॉइस पे धंधा करते हैं, पीओ लेते नहीं है, कुछ नहीं लेते हैं. एंड दिस इज वेयर I have to say statutory arbitration has been a brilliant tool for such micro and small business houses. MSME, the popular name is MSME और उसका और popular नाम है उद्योग आधार. अगर आपको पता है, आपने कभी ये शब्द सुना है कि उद्योग आधार नंबर, it means MSME नंबर, माइक्रो स्मॉल मीडियम नंबर. एक सर्टिफिकेट दिया जाता है, उसमें ना ऑन द बेसिस कि आपका टर्नओवर कितना है, कैसा है, आपको क्लासिफाई किया जाता है. अगर आपने देखा रहेगा 2020 में व्हेन द कोविड वाज देयर, वो तो टर्नओवर पे कर दिया था एमएसएमई को. सो द मोमेंट आई से एमएसएमई, हाउ स्टैट्यूटरी आर्बिट्रेशन कम्स इनटू पिक्चर. आई एम टेकिंग अ सिनेरियो जहां पे एक छोटा बिजनेस वाला है, उसका साल का इनकम अराउंड कुछ यू कैन से 25 लाख से टर्नओवर सॉर्ट ऑफ. उसने बिजनेस कर दिया, उसने इनवॉइस ले लिया, सब ले लिया, अब इसको पैसे नहीं आ रहे. नाउ व्हाट एमएसएमई हैज डन, it has done three things: best, better, and I'm telling you anytime better. Definitely it can improve, but it is already an improved act. It has defined when opposite party can raise the defect in the goods or services. Credit period दिया हुआ है 45 days. If you go beyond it, it is your mutual consent, fair enough, else 45 days. आप ये सब नहीं पालोगे, then you fall under MSME. Now what MSME has done is, मान लीजिए मेरे पास परचेस ऑर्डर है, मेरे इनवॉइस ले लिया है, पैसे ही नहीं आ रहे, राइट? अब आप सोचोगे मैं कहाँ जाऊं, मैं कोर्ट जाऊं तो मेरा खर्चा होता है, इतना टाइम वेस्ट होता है, मैं इतना कहाँ जाऊं. सो नाउ व्हाट एमएसएमई हैज डन, दे हैव केम विद दिस फंडा ऑफ एमएस काउंसिल arbitration. Now this is where I say it is statutory arbitration. It means even though suppose there are two parties, A and B, right? A have got himself registered as an MSME and he supplies the goods to B. B is not making the payment and there is no arbitration clause. Then A can directly go to MSME and start arbitration proceedings because the law has given them mandatory statutory arbitrations. And let me tell you, if suppose A has both the options, contractual arbitrations and MSME arbitration, or which is known as statutory arbitrations, he can decide which arbitration he wants to do. ऐसा नहीं है कि contractual है then statutory arbitration loses the right. No, statutory will prevail because that has been defined by the statute. But if a party chooses contractual, then definitely he cannot go for another remedy. You know that funda, right? CPC में for one cause of action you cannot have two remedies in the same part. You cannot. एक criminal एक civil चलता है, but civil में for same cause of action two नहीं चलता है. So if you have chosen contractual, go for it. If you have chosen MSME or statutory arbitration, go for it. दोनों का बेनिफिट क्या है? अच्छा, उसके पहले statutory arbitration वर्क कैसे करता है? आर्बिट्रेशन में कैसे सेक्शन 121 का नोटिस है, इसमें कोई मैंडेटरी नहीं है. इसमें आपका पैसे नहीं आता है, then definitely I will prefer कि आप उनको लीगल नोटिस इशू करो, आप उनको बताओ डिमांड नोटिस में कि मेरा पैसा आया नहीं है. वो नहीं आता है, as per the Bombay MSME procedure, you have to file an application. Application में you have to upload your purchase order and invoice, and then the major impact which MSME does is you can claim 3 times compound interest on your principal amount. And I'm telling you, no other remedy gives you that. No other, right? Because even if you go to arbitration contractual में 18% you can claim provided that it is there in your invoice. If not, then definitely there is an argument, interpretations, and most probably 12 से 15% आपको मिल जाएगा. बराबर है. आप स्टैट्यूटरी आर्बिट्रेशन में विदाउट एनी नोटिस you can directly approach MSME. I'm just pausing here now. Now this is little bit, I'm just trying to say that in Bombay के MSME में purchase order has been made mandatory. But I have seen that in another branches of MSME, in another states, I don't know to name it, but in other states, they also allow MSME offices, they allow without any purchase order. They also allow on telephone orders or affidavit, but somehow I'm not sure why here it is not being allowed. But what it has done is, it has informed, it has educated the MSME कि भाई purchase order तो ले लो. तो अभी मैं देख रहा हूँ कि ज्यादातर लोग purchase order लेना सीख गए हैं. Purchase order और invoice मैच होता है तो आपका MSME में केस बन जाता है. अब ये चलता कैसा है MSME में? एक बार आपका केस एडमिट हो जाता है कि योर केस इज फिट फॉर अंडर एमएसएमई, राइट? यू फॉल अंडर एमएसएमई कंसिलिएशन काउंसिल. फिर दे प्रीफर वन मीटिंग फॉर कंसिलिएशन. ऑपोजिट पार्टी को नोटिस जाता है, भाई आप कंसिलिएशन कर रहे हो क्या? नहीं मानता है, वो नहीं आता है, फेयर इनफ, दे विल गो फॉर सेकंड चांस. नहीं आता है, देन देयर इज अ प्रिस्क्राइब्ड फॉर्मेट. लेट मी टेल यू, दे हैव गिवन यू अ प्रिस्क्राइब्ड फॉर्मेट व्हिच इज नॉट देयर इन कॉन्ट्रैक्चुअल. प्रिस्क्राइब्ड फॉर्मेट है, आप वो फिल करो, खुद जाओ, फाइल करो. Then the notice is issued, arbitration starts. If they don't come in 1 or 2 dates, the matter gets closed, ex parte proceedings. And let me tell you one thing, the moment if I am saying ex parte proceedings, I think recently there was some judgment that if the matter is ex parte, right, ex parte, opposite party cannot file an evidence because that evidence has no role to play since he has not replied. Because definitely your evidence is based on your written statement. Ex parte ऑर्डर आ गया, एक बार ऑर्डर आ जाता है एमएसएमई में, अपील, जैसे बॉम्बे में द अपील इज टू द हाई कोर्ट एंड यू हैव टू पे 75% स्टे. डेफिनेटली कॉन्ट्रेक्चुअल आर्बिट्रेशन में भी अभी पूरा पैसा देना पड़ता है एज पर सेक्शन आई थिंक सो 36A. बट एमएसएमई हैज हेल्प्ड बिकॉज इट इज मैंडेटरी आर्बिट्रेशन. कॉन्ट्रेक्चुअल में जो लूप होल था, लाइक मेरा आर्बिट्रेशन नहीं है, एमएसएमई हैज कवर्ड. नाउ लेट मी टेल यू, एमएसएमई इज ओनली एप्लीकेबल टू एमएस, माइक्रो एंड स्मॉल, नॉट फॉर मीडियम. सो my suggestion will be is that enter into an agreement. It's better you enter into an agreement, have a contractual arbitration clause. Even if you are MS or MSME, have both the remedies in your place. And if third, wow, 138, and then you choose wisely which I want to have. So now this is contractual, this is statutory. So now let's understand कि contractual और statutory में benefits क्या है. कॉन्ट्रेक्चुअल में इट इज लाइक वहाँ पे इतना कोई देयर इज नो फोर्स कि आपको एविडेंस एक्ट के हिसाब से कंप्लाई करना है. सो कॉन्ट्रेक्चुअल में यू कैन डिसाइड योर ओन आर्बिट्रेटर, फलाना फलाना, राइट, यू कैन हैव योर ओन आर्बिट्रेटर, यू कैन डिसाइड किस तरीके से आर्बिट्रेशन चलाना है. सो बेसिकली यू आर द ओन पर्सन टू डिसाइड कि मुझे मेरा केस कैसे चलाना है. डेफिनेटली इट हैज टू मीट द गाइडलाइंस ऑन द प्रिंसिपल्स ऑफ नेचुरल जस्टिस. एमएसएमई में यू डोंट हैव टू से एनीथिंग. लॉज है, प्रिस्क्राइब्ड है, आर्बिट्रेशन ट्रिब्यूनल्स है, काउंसिल बना हुआ है, दैट्स इट. यू जस्ट हैव टू गो एंड कंप्लाई विद द एमएसएमई लॉज. सो द मोमेंट यू कंपेयर इट, एमएसएमई इज वाओ, इट इज गुड, राइट. यहाँ पे व्हेन यू गो फॉर कॉन्ट्रेक्चुअल आर्बिट्रेशंस, let me tell you 90% or let me say 95%, and if I am saying 100% I am not wrong, but ज़्यादा हो जाता है. 95% you have to hire a lawyer, you have to hire a lawyer. But MSME में it's your choice. It's your choice to appoint a lawyer or not, because MSME का एक prescribed rule है, procedure है. Contractual arbitration में you have to pay arbitration fees. यहाँ पे legally if you ask me no, but definitely it depends how it works out as per their own thing. आप contractual arbitrations करते हो, let me tell you, you can claim all your costs which have incurred in during arbitration. Like you have paid to the lawyer, you have paid to the arbitrator. Same is applicable to MSME. Even they have a right to do that. Fair enough. Contractual में section 21 notice is mandatory. MSME में there is nothing called mandatory. But now the most important part, MSME में how you can go. One, you need to, the supplier has to inform the buyer that I fall under MSME. Remember that. And how you will do that? Either you send an email or letter and get their approval. Even if they don't approve, fair enough, but at least you give them, and there is a acceptance part, or put in your invoice. So the moment you do that, law, you have complied, and MSME comes into picture. If you don't do that, there is a judgment which has come that if you don't do that, you are not informing the other party that you are an MSME and you cannot avail MSME. So there's a technical aspect, it might be changed later on, but as of now it is there. So I'm just saying that. So these are the basic bifurcations between what you say is contractual and statutory. Make it very simple. Contractual arbitrations में दो part है, ad-hoc and institution. Statutory is MSME. Go for it. Just go for it. Now, just a suggestion how you will cover this statutory when it comes to part, because most of people they were just understanding कि how to किस तरीके से हम arbitrations को handle करें या कैसे नहीं करें. Now see, there is a concept when I started my talk I said कि arbitration, conciliation, mediation सब होता है. Now हमने तो बातें कर ली आज statutory arbitrations क्या होता है, contractual क्या होता है. See, even conciliation is legal because the law says arbitration and conciliation. Mediation का जवाब नहीं है, but mediation I'm pretty much sure it plays a big role, because what happens is contractual ho ya MSME, what they do is the moment the matter comes first, the first suggestion is why don't you conciliate or mediate the matter and close it. In fact, in commercial suits nowadays, mediation has become mandatory. If you go for a commercial suit under Commercial Suit Act, mediation is mandatory. आप पहले उसको comply करो. Purpose क्या है we just try to see if the matter can be closed by mediating, and the moment as I'm mediating, definitely it is not arbitration, but the intention is let's set talk and try to close the matter. So even arbitrations में भी वही होता है, आप contractual करो या statutory करो. To go further way कि किस तरीके से आप statutory और contractual को और broad perspective से देख सकते हो, तो just ensure कि statutory arbitration में भी restrictions है. You need to be very clear. अभी एक सबसे बड़ा क्वेश्चन ऐसा आता है कि मान लीजिए I'm doing my business from 2015, right? And I just applied for MSME in 2020, and there's a recovery case of 2018. This is the majority of the questions. I'm pretty much sure it will be coming, whether MSME is applicable or not. Some say yes, some say no. For me, when I say from the legal, from legal interpretation and certain judgments, then definitely आप नहीं कर सकते हो, because that's why I told you, you have to inform others that you are an MSME. Now, this is not the case in contractual. Again, contractual only comes when there is a written agreement. Okay, famously उसको बोला जाता है arbitration agreement. Now, contractual doesn't mean कि आपका specifically contractual agreement अलग से होगा. आप कोई भी agreement करते हो, उसको अगर आपने clause भी डाल दिया, it amounts to contractual arbitration. That's it. And let me tell you one thing. Definitely, I don't want to get into the nitty-gritties of how it works, किस तरीके से चलता है. But suppose, and just suppose, मान लीजिए किसी ने arbitrator appoint कर दिया है, and you really feel that I'm not happy with this arbitration or something is missing. Arbitration Act has given you the right to approach the High Court and give your submissions. Definitely, if you are able to give your proper submissions, arbitrator might be changed. And that's why choosing an arbitrator requires a good mindset and definitely a little bit of your knowledge. So, this is where in contractual, you need to understand, you need the help of a professionals, lawyers. I will prefer that way. MSME में दिमाग नहीं लगाने का, ठीक है? Form देने का, application देने का, approve हो जाएगा, move on. They have their own system in place and everything. So if you ask me today, which is good, I don't want to say this is contractual is good or statutory, but definitely statutory arbitration prevails little bit higher than contractual. And I am seeing in this last 4-5 years, majority of MS micro and small, they have started availing this benefit. Then definitely because पैसे के हिसाब से ये कम भी है, there are no strict procedures, no prescribed कि आपको यही पैटर्न में देना है. Okay, you can give it as it is. ज्यादातर कानून उनको इतना फोर्सफुली लागू नहीं होता है, because even MSME office they expect that the parties who are coming, they definitely they don't have that technical or legal broad knowledge की इस तरीके से किया जाता है. But definitely it's better that you hire some professionals in both the matters and how to go about it. That's it. Just before ending statutory versus this part, see, definitely the future holds for arbitration, right? I have always preferred one thing, that start any business if possible with an agreement. But I'm assuming that धंधा करने बैठे हैं, हर कोई agreement accept नहीं करता है. Then try at least for purchase order. मैं ये expect करता हूँ कि purchase order भी नहीं मिल रहा है. भाई साहब invoice तो raise कर लो, आप invoice raise कर लो, at least show that there's a business transaction, and then you have at least one of the options open to you. जो मैंने अभी बताया, आपके पास एक ही ऑप्शन है स्टैट्यूटरी का. इफ यू हैव एनी एग्रीमेंट, डेफिनेटली दोनों एप्लीकेबल होता है. सो I am seeing a very a good future in contractual arbitration and statutory. Now either of this, and let me tell you, both the arbitration, contractual or statutory, which is definitely as MSME known, the reason it is helping even the courts, but from business point of view, this arbitration is nothing but a progressing step of each business houses, because I have seen that in arbitration, most of the matters, even if they are fought, they get closed in a very beautiful manner. No heartbreaking relationship between two business entities. I have seen companies where some A might have won, B might have lost, but they have started another business relation, definitely which you will not find in court, because court has their own prescribed rules and procedures. I'm just stopping myself from now going ahead, because I think I have covered the major part of contractual and statutory. I'm just closing with this point. Again, I'm just repeating, because statutory means MSME, prescribed law and arbitration. Contractual means you as a party have a right to decide मुझे कौन सा arbitration लेना है. Even ad hoc an institution has their own rights and benefits. MSME, as I told you, it has restrictions. Comply with it. As a lawyer, it has a good future. As a businessman, make it a part of your business strategy. That's it. Thank you.
So there's one question on the chat box. What if the party has entered into arbitration agreement and on breach directly approaches the court for relief?
They cannot. Okay, it's a good question because it has a sense to it. Suppose if two parties or more have entered into an agreement, okay, and there's an arbitration clause. Let me tell you, such party, they cannot approach court for any relief because they are mandatory bind by the arbitration clause. So suppose if someone goes to the court, you can file the dismiss application saying that the court does not have the jurisdiction to hear the matter because already there is an arbitration clause which is binding on the parties, whoever it is to the parties. So if that is the case, you can get the matter dismissed because if there's an arbitration clause, arbitration will prevail.
Okay, so there's one more question. What is meant by merit hearing and procedural hearing?
In what context?
So must be in context of arbitration, sir. मतलब merit hearing and procedural hearing कुछ होता होगा.
See, ऐसा है. I'll tell you what. Procedural hearing और merit hearing में let me tell you क्या होता है. आप arbitration जब start करते हो, right? हम उसको case management बोलते हैं. So there is, the term is using procedural hearing. Procedural hearing arbitration में क्या होता है? The day when you start your first arbitration, right? On that particular date, we prescribe the dates. Like आपका statement of claim should be filed on this date. Statement of defense on this date. If both the parties wants to take an inspection on this date, then admission and denial of documents on this date, and then evidence comes into picture. And then what you call the question is being raised कि आपको cross करना है क्या? Because if this matter can be decided from the documentary point of view, then no cross is required. This is being made. So on the first date itself, you cover 70% of the procedure in a manner. So arbitration में अगर आप देखोगे, I'm telling you, your first hearing starts when evidence is filed or framing of issues are be done. So, you can say procedural hearings if you're telling me there is nothing as such procedure in arbitration. You decide the dates what you want to do, and the moment you are done with, you directly start cross. That's why I said when arbitration is there, the best benefit, you don't have to get into this hearing part. But yes, suppose if someone wants an interim relief, ऐसे बहुत सारे मैटर्स में क्या होता है कि बहुत सारे लोगों को इंटरिम रिलीफ चाहिए. आर्बिट्रेशन हैज टेकन केयर, एमएसएमई में भी है वो, राइट? क्या है केयर? यू कैन फाइल सेक्शन 9 का पेटिशन बिफोर हाई कोर्ट फॉर एड इंटरिम रिलीफ और इंटरिम रिलीफ. सेम यू कैन आल्सो फाइल अंडर सेक्शन 17. सपोज आपको रिलीफ इतना अर्जेंट चाहिए दैट यू कैन नॉट वेट फॉर द आर्बिट्रेशन टू स्टार्ट और टू फॉर्म, अप्रोच हाई कोर्ट एंड गेट एड सेक्शन 9 एंड interim relief. Suppose if arbitration is formed and in between you feel there is some issue, go for interim relief. So if you see arbitration works in that way, this is what the arbitration is all about. But MSME थोड़ा different है. MSME में क्या होता है? आप applications file करते हो, accept होता है, conciliation के लिए जाता है, 2 बार वो नहीं आता है, आप synopsis के साथ petitions के साथ annexes देते हो, वो नहीं आता है, 2 dates ex parte होता है, and if documentary evidence is filed, order is passed. So in both ways, MSME is always, it doesn't have any procedural hearings. Process set it away. आप आगे बढ़ाओ.
So my question is, what are the circumstances and grounds under which arbitration agreement can be inoperative or unfit to be performed?
Okay, number 1, if your arbitration clause does not give the clear picture, okay, I'm taking this. I'm just reading one statement which definitely was there in one of the agreement. This agreement will be governed by the provisions of Arbitration Act. Full stop. Managing director of this company will become the sole arbitrator. Finish it off. That's it. Arbitration clause is valid, but arbitrator is not valid. Number 1. When your arbitration clause is not being, drafted in a manner which gives an impression that it is an arbitration clause, like this. Any dispute arising out of this agreement shall go to the mediation. This is not arbitration. Third part. Suppose one agreement was there in which stamp duty was supposed to be paid, and there's an arbitration clause, and the dispute came. earlier the stand was, if the stamp duty is not paid, arbitration cannot start or there is no validity to that part. But of late, fair enough, arbitration को कोई हाथ नहीं लगाएगा, arbitration will be starting, but you have to comply with the stamp duty part. Inoperative will always be there if you don't comply with the Arbitration Act. Suppose you say that either of the party will appoint 2 arbitrators and that will comply with the arbitration tribunal. It is illegal because law says arbitration tribunal has to be odd. It cannot be even 1, 3, 5, 7, whatever. So you need to be very clear कि हम draft कैसा कर रहे हैं. Inoperative एक और तरीके से हो सकता है. Suppose if the agreement itself is void or void ab initio or agreement itself is a dispute, then definitely it will not come. Now suppose there is a rental agreement and you put an arbitration clause. It is not valid because rental agreement are definitely they fall under small causes code. It's a very specific act. So if you know sometimes your agreement decides whether that agreement is valid or not. So the moment agreement becomes valid, then arbitration has to be valid. But suppose if your agreement falls under some statutory obligation, okay, and there's an arbitration clause which is trying to bypass, it cannot. Example, there's an agreement with the builder. You are buying a property and builder, there's an agreement. There is an arbitration clause. Today, nowadays, you have 3 options: Consumer Act, RERA Act, Arbitration Act. You have 3 options to go. You can do that. No one will stop you. But suppose if that builder agreement or whatever is agreement is not duly registered or the whole intent of the agreement is not valid, then there is no case of arbitration. Yes, but there is a plea that even if it cannot be argued, the matter should be referred to arbitration and let that order is passed. See, if you see the judgments of how the arbitration agreements have become relevant and effective, see, even the courts have started giving more you can say fight to ensure that the matter goes to arbitration, because even they want that the matter should go to arbitration and just see to it that the matter is coming with a very good you can say closure. Definitely there was a latest judgment that if you fail to give any evidence at the time of trial, you can definitely go for an appeal part. There's a debatable part we will see later on, but definitely you have this particular scenario. Just remember one thing: if arbitration clause is a part of the agreement and the agreement itself is invalid, there is no purpose of having such an arbitration clause.
Okay, sir. So there's one question again. Does the statutory arbitration only apply to micro and small enterprises?
Yes.
Okay.
So there's a reason behind it, because they want to protect them, because sales turnover of medium has become higher nowadays.
Okay. So sir, when was it enacted?
Which one?
This protection to the micro and soft statutory arbitration for
MSME Act, it came in 2006.
Yes.
Okay, and in fact, if you go to this part, if someone has a doubt whether MSME medium comes or not, see, the name of the council is being given as MSEFC, Micro Small Enterprises Facilitation Council. So there is no medium to it.
Okay.
Before pandemic, before COVID, hardly you can say a little bit of majority was giving the importance to this MSME. But in COVID, I'm telling you, the ratio has jumped. If it was 10%, it has jumped to almost 60%. Almost.
Due to different.
Due to COVID and everything. Because in COVID, everything started realizing that MSME bhi hai, usme provisions bhi hai, acha ye bhi compliance hai, itna to it's a very cheapest form of getting the things done.
Yes, sir. And so the dispute must be because of deferred payments mostly, right?
Yes. In COVID, majority of the matters was only 3 matters. One, deferred payments, moratorium, or defamation. 2 साल में से भी 3 ही matters ज़्यादा चल रहा है.
Defamation.
हाँ.
So can you little elaborate on what matters on defamation among the common people?
No. It's like this. What I was trying to say कि COVID में 3 चीज ज़्यादा चला. COVID तो चल ही रहा था. One was deferred payment, so MSME came into picture. सबको moratorium में मतलब सबको लोन का requirement था, so public started giving importance to MSME. और तीसरा, COVID में ज़्यादा defamation चल रहे थे. which are not related to MSME or something.
Yes, sir. Politicians and celebrities. Okay, like that.
In between, I mean to say anytime, anywhere, whoever it
Okay.
is in between.
Yes, sir.
Thank you. I wish you all the best, everyone.
Thank you.